Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. All right, let's talk about your case management system. Maybe you're still drowning in spreadsheets or stuck with software that feels like it's from 2015. No offense, 2015. The podcast friends at e-immigration recently published an ultimate immigration software buyer's guide. I wish I'd had it when I was shopping for our firm's case management system. It's got real comparisons of the features that actually move the needle. Head to get.eimmigration.com/resources to grab your copy and pick like a pro. Or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Big news in immigration this week, so what to pick? Well, Kilmar Abrego Garcia was released from custody and is now at home with his wife and family. The DHS secretary whined about it on an official government website like a child. And Judge Williams in the Southern District of Florida, God bless her, seems to have put a stop to the alligator abomination in the Everglades, not real alligators, the immigration prison, just before hurricane season gets into full swing. Can I exit this timeline or fast forward a few years? This is a lot, guys. This is a lot. Also, just so you know, I didn't miss it. The Fifth Circuit published a citizenship remand late Friday evening. But as it is a long decision and it was late Friday evening, I'm doing it next week. Stay tuned. If nothing else, it'll give us something to talk about next week. Be happy with these four. And be happy for federal district court judges who care about the law. On to the cases. Starting off with Moncada v. Rubio, published by the Ninth Circuit on August 20th, 2025. Is this the first Rubio respondent defendant on the podcast? Might be. This is a tough one about birthright citizenship. Not everyone is entitled to it, you see. And it's a long one. Mr. Moncada was born in New York City in July 1950. Everyone recognizes this. His father, you see, is a Nicaraguan national, and he worked for Nicaragua's permanent mission to the United Nations. Mr. Moncada has lived in the United States as a U.S. citizen for nearly 70 years. He has received a U.S. passport 5 times. Quote, in the district court's words, a child was born in America and told by the United States government, his government, that he was an American citizen. And it told him this again and again and again and again. End quote. Until it didn't. In 2018, the State Department reviewed its records and found that Mr. Moncada's father had served as an attaché, not a consul, when Mr. Moncada was born. And that made all the difference to state. It revoked his passport. Mr. Moncada sued, but lost in district court before what appears to be a sympathetic judge. The Ninth Circuit affirmed. Let's dive in. First, being very aware of the moment, the Ninth Circuit begins by stating the law. Quote, Mr. Moncada was born subject to the jurisdiction of the United States under the 14th Amendment unless he was born with diplomatic immunity from the jurisdiction of the United States. End quote. That, would appear, is the only exception to birthright citizenship, the long-recognized exception. Whether Mr. Moncada had diplomatic immunity depends on whether his father did in 1950. Quote, that in turn depends on whether the president, Truman, at the time, received Mr. Moncada's father, Dr. Moncada, as a public minister, or whether Dr. Moncada served as a consul instead. End quote. There's a difference between consuls and public ministers, you see. The president essentially has a constitutional obligation to accept ambassadors and public ministers from other countries, but has no corresponding constitutional duty to admit consuls, the people working in the embassies and consulates doing the day-to-day grunt work, I imagine. James Madison apparently said it in Federalist Paper number 42. Didn't you know? Admissions of consuls and the like are generally subject to treaties and therefore all have different forms of immunity or none at all, once in America, depending on the agreement that America makes with a foreign country. Ambassadors and public ministers have full diplomatic immunity, always. So too United Nations representatives. And with limited exceptions, this all extends to public minister families, too. Quote, consuls, on the other hand, hold immunity only for their official acts, end quote. The Ninth Circuit explains in a few pages how this all goes down in practical terms between foreign governments and the U.S., and it's interesting stuff. Now, an attaché is a public minister, it appears. Mr. Moncada, of course, argued that his father wasn't that, but was instead a consul when he was born. And he's got good evidence for it, although much of it has been lost in the last 70 years. Quote, various documents, including his birth certificate, list his father's occupation as deputy consul. And in an exequatur from May 1949, wherever that is, President Truman recognized Dr. Moncada as consul of Nicaragua at New York, New York, end quote. So, strong stuff. But the next year, a United Nations document lists the father as both consul and attaché, and several U.S. government records showed that he was an attaché. Probably worst of all for Mr. Moncada, given my own experience with cases like this, is that his father appears as an attaché in the official August 1950 Department of State Registry of Diplomats, the Blue List. Other government records support this too. At trial, a U.S. government representative testified from the State Department, but as their primary piece of evidence, they relied on a certificate of diplomatic immunity for the family for the period 1950 to 1955 that the Department of State had created just a few years ago. The district court appropriately did not give that conclusive weight, explained the Ninth Circuit, but it still affirmed the lower court's denial of a declaratory judgment for Mr. Moncada. Now, without implicitly getting in another dig at this current administration, though, quoting the seminal and recently very important case, United States v. Wong Kim Ark from 1898. The Ninth Circuit explains, quote, the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens, with the exceptions or qualifications, as old as the rule itself, of children of foreign sovereigns or their ministers, end quote. Indeed. That said, if the executive is going to grant full diplomatic immunity to a foreign individual, it is, quote, conclusive on all domestic courts, end quote. So it's powerful. But yet still, courts can decide whether that actually occurred, explains the Ninth. Returning to Wong Kim Ark because, heck yeah, quote, in the absence of a controlling provision of the Constitution, no legislation or executive action denying a person's citizenship can constrain or permit the judiciary to refuse to give full effect to the peremptory and explicit language of the 14th Amendment, end quote. Turning first to that certificate of diplomatic immunity then. It's probably often going to be conclusive, not least of which because courts can't second-guess the executive's decision to grant full diplomatic immunity to an individual. Here's looking at you, former Brazilian President Jair Bolsonaro. Let's see what happens in the coming years. But distinguishing some prior and Supreme Court precedent, quote, we need not credit the Secretary's certification of a foreign representative status presented during litigation to the exclusion of all other executive evidence, end quote. Certificate created 70 years after the fact? Gonna need more proof, explains the Ninth Circuit. In so holding, though, it does create a circuit split with the D.C. Circuit of all circuits and rubs up against the holdings of a few more. The certificate's still important, though. And unfortunately for him, like all people claiming U.S. citizenship, Mr. Moncada has the burden of proof, which is often deemed a heavy one. Now, the Ninth Circuit explains that Mr. Moncada actually met his initial burden by presenting proof of receiving 5 passports, thereby flipping the burden of the Department of State to rebut, by clear and convincing evidence, no less. That is, that the father, Dr. Moncada, had diplomatic immunity when Mr. Moncada was born. Met despite the conflicting evidence, explains the court. It gets pretty into the weeds on the facts, but the Department of State's evidence included the credible testimony from that State Department representative about the diplomatic process, documents from the U.S. mission to the United Nations, the blue list, the registry, lots of documents showing Dr. Moncada's name as an attaché, a registry of UN General Assembly records showing that Dr. Moncada spoke in a diplomatic capacity, and other documents. In rebuttal, Mr. Moncada had that Truman thing and his birth certificate and some not-so-helpful testimony from the Department of State representatives showing that maybe the representative doesn't know exactly what happened in 1950 because how could he? But still, explains the Ninth Circuit, it was reasonable for the district court, the fact finder, to side with Mr. Rubio's representatives in court rather than Mr. Moncada. Not gonna lie, it's a bit of a dud of an ending to such an interesting battle royale of a case. Standards of review and deference to the lower court type things strike again. Quote, the district court also observed that it is impossible to conclude that this is justice, and we share its concern about this outcome. The government, for its part, concedes that its decades of mistakes led to this very unfortunate and regrettable situation. But as inequitable as this result is, courts lack the equitable power to remedy the government's errors by granting Mr. Moncada citizenship, end quote. Let's see if the executive exercises its equitable power to remedy this wrong to the maximum extent it can. Godspeed, Mr. Moncada. And that is Moncada v. Rubio. It's another week, so you know I've got BIA decisions. The first one is matter of Buri Mora, published by the BIA. The Attorney General has decided to make precedential a formally non-precedential decision about extreme and exceptionally unusual hardship. By the way, I'm pretty sure there have been over 30 precedential BIA decisions since Trump returned to office only a few months ago. Astonishing, really. Any complaints that a future Democrat administration somehow abuses an agency's power will fall on the deafest of ears of this podcast. By all accounts, Mr. Buri Mora is an excellent person. He's from Ecuador. An immigration judge granted him non-LPR cancellation of removal and therefore the ability to receive a green card and remain with his 3 U.S. citizen children and U.S. citizen wife in America when a number becomes available for a green card in a few years. DHS decided to appeal. The BIA took away Mr. Buri Mora's nearly guaranteed path to a green card. To obtain non-LPR cancellation of removal, Mr. Buri Mora needed to show that at least one of his 4 qualifying relatives will suffer extreme and exceptionally unusual hardship without him. He must meet this heightened standard because Congress got rid of suspension of deportation in 1996. And he can't adjust to LPR status in America or a consular process abroad without remaining outside the U.S. for like 10 years because Congress took away adjustment eligibility for people who entered unlawfully and implemented the 3- and 10-year bars in 1996. So, funneled into the only relief available to him, longtime resident of America and seemingly good person, Mr. Buri Mora pursued it when DHS decided to place him in removal proceedings. The BIA's seminal matter of Monreal decision explains that only hardship, quote, substantially beyond that which ordinarily would be expected from a close family member's removal, end quote, will cut it. If unmet, America is all in for splitting up families, end quote. If the hardship is based on the health of a qualifying relative, the respondent should establish that the health condition is serious and that adequate medical care would not be reasonably available in the country of removal if the relative accompanies the respondent, end quote. The BIA disagreed with the IJ's hardship finding respectfully. After all, the children are staying in America, and so even without Mr. Buri Mora's presence and income, the BIA explains, will continue to receive services in America by relying on Medicaid and tax-funded New Jersey programs. So, quote, while the respondent's daughter has been diagnosed with autism and an anxiety disorder, and his sons have been diagnosed with developmental delays, the conditions of all 3 U.S. citizen children are presently being managed by individualized education programs or early intervention services, end quote, again, paid for indefinitely by New Jersey taxpayers. That it will continue or get worse with Mr. Mora's removal and inability to support the family financially is not hardship enough to the BIA. That his wife will have to raise 4 children on her own and work a lot more hours to get by is also insufficient to the BIA, given that she has a good job and receives support from her family in the United States. And quote, economic detriment of the nature presented in this case is a common feature of a parent departing the United States, end quote. The U.S. government decided to detain Mr. Mora, so who knows, maybe he has a criminal record, I don't know. But this decision does not mention it, and I'd expect this BIA to do so. His detention has caused the autistic daughter to develop behavioral issues already, and her grades have already suffered. And she's really close with her dad, as are all of the children. Still not hardshipy enough, explains the BIA. I do not see the BIA as having aggregated these hardships as the law requires. But nevertheless, the BIA deemed the hardship lacking and ordered Mr. Mora removed to Ecuador. And that is matter of Mora. Continuing with matter of OYAE, published by the BIA. The Attorney General has decided to make this precedential, a formally non-precedential BIA decision denying Convention Against Torture Protection from Venezuela. And look, everyone, as some of you know, I have interesting circuit and even Supreme Court decisions that are immigration adjacent, ready to be reviewed on down weeks when there aren't that many publications. This week was looking like such a week. Right now, you are being deprived of a review of a very interesting Supreme Court case from last term that is immigration adjacent because of the BIA's prolific absurdities. Please write to the BIA to complain. Email address on the BIA's website. The respondent in this case served in the Venezuelan military as a counterintelligence officer and lieutenant. She fears she will be beaten, kidnapped, detained, tortured, and/or killed if she returns to Venezuela due to her refusal to comply with her commander's order to falsify a document. Indeed, explains the BIA in a footnote, Ms. OYAE apparently refused to sign off on a Venezuelan military terrorist activity. Seems like a noble refusal worthy of praise. Due to that same military service, however, the immigration judge first found that she had a serious non-political crime and persecutor bar to asylum and withholding of removal, so no small thing. That left only cat deferral, which the IJ granted. The commander did, after all, threaten to kidnap, imprison, and torture and kill Miss OYAE and her family. She has personally witnessed the torture of another similar officer, and that commander sent an armed military unit to her home looking for her. Plus, the very bad Venezuela country condition reports. Plus, she was a counterintelligence officer for years, meaning that the Venezuelan government can obviously identify her upon her return. How does this not qualify? Well, it doesn't to the BIA, sustaining DHS's appeal. The BIA hates the Convention Against Torture, as does the Attorney General. They just hate it. Too speculative a cat claim, explains the BIA. Remarkable. Yes, this commander is specifically under European Union sanctions for human rights violations. But, explains the BIA, Ms. OYAE was able to retire from the Venezuelan military and from 2021 to 2024 was not harmed or threatened in Venezuela. It seems like the IJ misread the record on that fact. Seems like the IJ thought that a threat occurred between 2021 and 2024, which pretty much formed the basis for the BIA to latch on and vacate the CAT grant. That's pretty much it. The BIA doesn't really tangle with the record evidence, summarily rejects that EU thing without germane citation or analysis, and simply says that Miss OYAE didn't meet her burden. In fairness, it's probably written like this because it was never supposed to be precedential in the first place. Something that would make sense with a decision like this, based almost exclusively on an apparent factual mistake committed by the IJ, which would literally never intentionally occur in any other case, and so is not in need of a precedential decision. It's the BIA and Attorney General's weird world, and we're all just living in it. I would welcome this case on a parent Ninth Circuit petition for review, if anyone's interested. And that is a matter of OYAE. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Our final case is a matter of GCI, published by the BIA. This case is about credibility. Mr. GCI, an acronym of course, is from the country of Georgia. He claims that he was physically harmed and threatened by police officers in Georgia because of his membership and support for the United National Movement, or UNM, an opposition political party. He testified that in support of the UNM, he helped transport people to the polls and helped his brother, who was a leader of the youth wing of the UNM. He claims that he was physically harmed by police in Georgia on 2 occasions, hospitalized both times. He sought asylum in France but didn't get it, and was beaten again and hospitalized, and then came to the United States through various countries. Beaten in Georgia, not France. Ineligible for asylum due to the circumvention of lawful pathways rules, something not yet addressed on this podcast, but surely to be addressed in the future. Mr. GCI applied only for withholding of removal and cat protection. An IJ denied the claims, deeming Mr. GCI not credible. The BIA affirmed. Seems that the IJ's main basis was that Mr. GCI's testimony in court about when he became involved with the UNM wasn't consistent with Mr. GCI's credible fear interview, which kicked off these proceedings. 10-year difference in the date, in fact, according to the BIA. Neither the IJ nor the BIA appear convinced by the respondent's testimony that he, quote, may have remembered the facts differently at the credible fear interview, end quote. Mr. GCI explains on appeal that 2015, 10 years later, is when his more direct activism began. But the BIA doesn't seem interested in this because Mr. GCI didn't directly provide this explanation at the hearing itself, even if that is a possible interpretation of the testimony, explains the BIA. Plus, explained the board, the IJ also permissibly found aspects of Mr. GCI's story implausible. Telepathing future denials, quote, specifically, the IJ found it was not plausible that the respondent did not investigate how to lawfully enter the United States or communicate with family members in the U.S. about the best way to enter. Given the respondent's extensive travel across many countries to enter the U.S., his early experience navigating the asylum system in France, and his statements that he communicated with family members in the U.S. during his journey, we discern no clear error in the IJ's assessment." End quote. Plus, the IJ didn't believe Mr. GCI received an anonymous call 2 years after being out of Georgia, as he apparently testified. And according to the IJ and BIA, Mr. GCI was unresponsive and evasive. Answer questions directly and then explain and contextualize if necessary, I always advise clients. The IJ also properly believed that Mr. GCI hadn't corroborated his story. Under the INA, quote, "The testimony of an applicant for asylum and withholding may be sufficient to sustain the applicant's burden without corroboration, but only if the applicant satisfies the trier fact that the applicant's testimony is credible, is persuasive, and refers to specific facts sufficient to demonstrate that the applicant is a refugee." End quote. So right off the bat, that's an issue here, right? Already deemed not credible? So the BIA begrudgingly acknowledges that credible testimony alone can win a case for a non-citizen. I've never seen the case myself, but it does exist, and even this BIA recognizes that it can exist. But often corroboration is required for those fleeing for their life, explains the BIA. Unless, of course, as the statute explains, the non-citizen sufficiently explains why he or she, quote, "cannot reasonably obtain the evidence," end quote. Now you've got matter of lack from about 10 years ago out of the BIA. And matter of lack provides a somewhat complex series of steps that an IJ should take when further corroboration is required. In the Ninth Circuit, at least, there's case law indicating that a continuance is a pretty safe bet for an IJ to take. But still, quote, "an immigration judge is not required to give a respondent advance notice of the specific corroboration necessary to meet his or her burden of proof or provide an automatic continuance for a respondent to obtain corroborative evidence," end quote. In a footnote, the BIA specifically mentions the Ninth Circuit in Wren and the Chuck Wu decision of the Third Circuit, circuits where advance notice and a continuance may be required. Having so cited those cases, quote, "we encourage circuits with contrary authority to reconsider the issue," end quote. Pretty incredible. Returning to Mr. GCI, his, quote, "generalized country condition evidence," end quote, was not sufficient, particularly as there was medical evidence and letters from his alleged political affiliates that could have been presented, identified by the IJ. And the agency doesn't like Mr. GCI's answers to why they weren't included, vague and not persuasive to the IJ and the BIA. That means that withholding of removal remains denied. Now, the BIA recognizes that a Convention Against Torture claim can still survive an adverse credibility finding, including in the Fifth Circuit, where these proceedings originate. But to the BIA, the IJ did consider this possibility. The IJ noted that the country condition evidence submitted didn't depend on Mr. GCI's credibility, but it was simply generalized, and, quoting the Fifth Circuit, quote, "generalized country condition evidence tells us little about the likelihood state actors will torture any particular person," end quote. To the BIA, the problem with this evidence for CAT purposes is that, quote, "it provides no insight into the respondent's political activity or any past harm, which are key to assessing his claim that he will suffer torture in the future," end quote. Mentioning, as it now does, that Mr. GCI will owe up to $998 a day for not leaving, the BIA affirmed the IJ. Here's a bee in my bonnet. Not commenting on this case specifically necessarily, but on CAT cases generally. The case law seems to be going more and more in a direction whereby CAT applicants can't succeed without evidence specific to their claim. Like here, where the BIA is requiring specific evidence of past torture or specific evidence of the respondent's political activities in the country condition evidence. But that can't always be the rule, that all of that is always required. There must be classes of people, Jews in pre-war and wartime Germany, Tutsis in Rwanda, etc., who could theoretically succeed on a CAT claim without presenting anything except proof of their religion or ethnicity and generalized country condition evidence, right? I get it, maybe such groups are few and far between, maybe. But the case law percolating at the BIA and throughout some circuits that sometimes seems to imply that generalized country condition evidence can never win a CAT case, and that there must be evidence very specific to the individual applicant, seems intellectually dishonest. Just want to get that off my chest. And that is a matter of GCI. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.